Hi, my name is Goldman. I'm the director and founder of Goldman and Associates. Our firm primarily focuses on family law and family law related issues. Please subscribe to our channel to see our videos in this regard. Today we're going to tackle the issue of how a father can win a custody battle. That's a question that was asked by our viewing audience. The truth of the matter is it presupposes an old notion that somehow fathers have a bias against them in the legal system to gain custody. It's really not true, folks. I mean, the court has made every effort to take away the focus from the qualities of the father and the qualities of the mother to focus primarily on what's in the best interest of the child. The child has become the focus. Now, it could be that evaluating what's in the best interest of the child might result in a determination that mom is best suited or that dad is best suited. It depends on a lot of things. You may be equally suited to the mom, for example, to have custody, but if you're working 12 hours a day, and by the time you would come home, the child would already be asleep, and therefore, if you had custody, there'd be nannies and babysitters raising your kid. Don't expect to go with that schedule and that the court will choose babysitters to trump the mom. It's probably not going to happen. But all things being equal, you as a dad are equally entitled to come before the court and say, hey, I want custody too. I want to share the custody. My rights should be equal to hers. And you know what? The truth of the matter is, this is true whether you're married or whether or not you're married. The only difference in the two scenarios is how it starts. When you're married, that is to say when the child is a product of a marital union, in that scenario, both parents kind of start out equally, with equal footing and an equal opportunity to seek custody. There's no presumption that she has custody and you don't. The presumption is you both have custody. You're married, you're living together, you both have custody. In a non-marital union, the presumption starts out differently. A non-marital union, there's no such presumption that it's joint. In fact, the presumption more likely is that it's the custody is with the mom, who in that situation is probably taking care of the kid. However, that's only how it starts out. Fathers, even in a non-marital union, have the right to come before the court and say, I want custody too. And then the court has to determine, is there a reason to look into custody? Once it does, once it decides that it would be fair to at least consider the possibility, the court will conduct an appropriate evidentiary hearing to determine what's in the best interest of the child. Should we leave the child with mom? Or should we consider a switch of custody, give the child to dad? And it could be that leaving the child with mom is the way to go. On the other hand, most of the time when people come to us and they want to take the custody away from the mom, it's because something's going on. The mom, is a drug addict or an alcoholic. The mom's been evicted 6 times. I mean, the mom is not stable, not providing a stable environment. Under the mom's watch, the kid has missed 42 days of school in the last 4 months. That's a problem. That's the kind of thing the court might say, wait a minute, we've got to revisit custody because something's going on here, and I'm going to have a hearing. Now, whether or not the court, because of that hearing, switches custody or not, it's a different story. That's going to depend on the proofs. That's going to depend on what the court sees in the way of the evidence that is produced by the dad. But there's no question that even in a non-marital union, the father does have the right to go and pursue that custody. If you're in that situation, either bringing it or defending it, give us a call now, and we'll be glad to help you out.